this audience also need no introduction formally for the CAV Jagdishan. We directly go to the topic.
Some of the participants are still waiting outside, and generally where you have a course continuously for 6 days, certainly there is thinning down on a day-to-day basis. But so long as there is one person before me, I have to do my job.
I am besides you, sir, always.
That is no significant. Opposite, one person should be there. You would have noticed that this topic is somewhat not a subject which has been given that name in any of the refresher courses or seminars. I chose the topic because in a refresher course, one has to study the subject in depth, unlike in a seminar or a conference where such an exercise is possibly not necessary. You will find that this topic is a very narrow topic, deemed perquisite in respect of computation of income under the head salary. Possibly this topic may not be on a day-to-day schedule of a taxpayer or a tax consultant, but sometimes when it comes, the burden is very heavy, as you will see when we take up this subject in detail. You are aware that in the case of salary, unlike in the case of other taxpayer, the initial burden of paying the tax on salary with reference to an employee is on the employer. In other words, he has to pay his own tax by computing his total income. He has also to deduct tax at source with reference to all his employees in accordance with the provisions of the Act. All the employers are deducting tax with reference to all their employees and filing the returns, giving the data as required in respect of tax deduction at source, on salary as well as on other payments. You will find that today the return is not processed in every case by verifying the data furnished in the return. Only a few returns are taken up for scrutiny. And even where the assessing officer takes it up for scrutiny, he has no time to verify whether the employer has deducted tax correctly, computed the salary income correctly for each of the employee. He only goes into the broad data furnished as to the tax deducted and the tax remitted. Whether the tax deducted is correct or not, is not able to verify. And though he has got the power, in actual practice it is not being done because of various reasons. See, government felt that making so many rules, making so many statutory provision regarding tax deduction, computation of income under the head salary, they don't have the machinery to verify whether these things are being done in accordance with law. So over a period of time, government started of finding out ways and means to verify this data. A suggestion was made that a separate wing of the department should be created for managing and verifying tax deduction at source. That's why we will find now TDS circle being formed at various places. The function of this circle is to verify not only in respect of salary, but in respect of other payments to which provisions apply for tax deduction at source. Now, what are the ways available to this circle to verify? For a long time, they were confined to their offices in verifying the data. But then it was found that the verification did not produce the desired result. Possibly last year or even before that, the government decided to improve the method of verification by the TDS circle, and they directed the TDS circle to conduct survey at business places, verify the records on the spot and find out whether tax has been deducted properly, and with a direction that more attention should be given with respect to salary. One of the areas where there has been always a difference of opinion between the taxpayer with the employer and the assessee who is the employee and the department as to what is perquisite, which should be reckoned for the purpose of computing income under the head salary and to apply the provisions relating to tax deduction at source. You will find that the term perquisite is not defined in the Act. Possibly inclusive definition has been attempted, but you will find that so far as perquisite is concerned, most of the computation, the creation of liability is relegated to the rule-making authority. So by merely looking at the section, you cannot find out what is the perquisite. So one of the rules which takes into account the computation of the value of perquisite is Rule 3, which runs into several pages. And those of us who are looking at the rules would have found that the rules were being amended from time to time. Now I will take one example or an illustration with reference to perquisite and with reference to the subject matter of today's discussion, deemed perquisite. For a long time, the terms of employment and payment of remuneration was in the hands of the employer. But you will see over a period of time, things have changed. It is the employee who dictates terms as to what he wants. Now, whenever this situation has forced the employer to listen to him, you will find that the employee, who is to be paid a very fanciful salary, demands lot of benefits, lot of advantages besides a mere cash payment. In other words, he wants to live in the same luxury as the employer. He feels that but for him there is no business. He is the king of that industry. So today they want accommodation. One of the most important demand of an employer, of an employee, is accommodation. Accommodation is the most difficult. So employer is compelled to provide accommodation, either rent-free accommodation or concession in the matter of rent. Well, there may be accommodation owned by the company, leased by the company, but whatever it is, the employee wants to have the benefit of an accommodation suitable to his grade of employment. Now, over a period of time, because of the rigid rules for computation of perquisite, employers have been adopting very intelligent methods to get over the provisions relating to computation of perquisite with reference to residential accommodation. Now, if you see section 17(2)(4), it says any concession in the matter of rent relating to accommodation provided by the employer is a perquisite. The words are any concession. It's not only the concession, there should be a benefit. Both should go together. Concession and benefit should go together. Now let us examine a case of a hospital. When we say hospital, we always think about Apollo Hospital. No, I don't want you to think about Apollo Hospital. Think of an hospital which is in a rural area, where the hospital requires all the doctors, nurses, etc. to reside very near the hospital, because a patient cannot wait for the doctor to reach the hospital, because patient will reach earlier elsewhere. So these are compulsions of the employer and of the employee. Now when such an accommodation is provided by an hospital to a doctor or to a nurse or a paramedic or a hospital staff what is the benefit? Because perquisite is a benefit. The doctor would like to live in a city nearby or a town nearby, but he is not allowed. Now, is it a benefit? Can you apply this rule? The employer has to compute the benefit, deduct the tax. And if he doesn't do it, well, the employee has to pay the tax. So this is a question which has been debated. First, what is a benefit? And number two, what is a concession? The rules prescribe the concession in a very indirect manner, as the rule existed originally. It said that the concession and the benefit will be equal to the difference between the market value rental of the accommodation and actual rent realized by the employer from the employee in the matter of concessional rent, and where there is no concessional rent, the entirety of the annual value on the basis of market. Now, what is the market rent for a accommodation in a remote hospital area? Who will come and stay there? Is it possible? So, lot of debate went. Associations of employees, association of employers filed cases before the court, and court felt that the concept of market value is not a market value which should be adopted based on the floor area or the comforts and all that. It should be with reference to the property for which the accommodation is provided and whether it has really any market value. In view of large number of litigation on this issue, the rule was modified. That is the rule which is now existing. The rule simply prescribed that the market value is not market value that you have to determine for each and every property, in the case of each and every employer or employee, because it is very difficult and is giving rise to lot of problems. We will fix a standard percentage on the salary of the employee. So the rental value, which is according to the department market value, is an ad hoc percentage of the salary of the employee. For example, if a doctor is paid 5 lakhs per month, and depending upon, they have given various percentages, 15%, 10%, 7.5%, depending upon the population of that area. And let us take the minimum, 7.5% is the minimum. So 7.5% of 5 lakhs will be the rental value. It's a very artificial value. As soon as this rule of thumb method was introduced in Rule 3, litigation started, saying such a rule is impracticable. You cannot create a benefit by a rule of thumb method. Benefit should be real. It should be felt by the employee. While fighting that litigation, a parallel issue was also raised that the rule makes differentiation between an employee of the government and an employee in the private sector. and therefore they said it is unconstitutional. You cannot make a distinction between a government employee for whom there is no benefit, whatever be the size. For example, if you see the general manager of railways is occupying a building in a 20-acre area land with 10,000 square feet of built up area, and there is no perquisite for him. So you find that persons who are officers of the government are not subjected to Rule 3 estimate of perquisite, whereas an employee of a private organization is compelled by Rule 3 to pay 7.5% deemed perquisite. It's a deemed perquisite. It is not real. It may be less or it may be more, but it is not real. The Supreme Court said, of course the matter went stage by stage, Supreme Court said in a very recent decision that bifurcation of application of Rule 3 with reference to a government servant and others is constitutionally valid. You cannot question the power of the government to prescribe differential method of computing perquisite as between a government employee and employee of a private sector. But on the question of merit as to whether there is a perquisite, whether a perquisite can be a pure 7.5% of the salary, there was long discussion. If you read that, I will give you the citation. Long discussion in the order, in the judgment, where the Supreme Court said that perquisite should be real and not notional. And therefore they struck down Rule 3, where it prescribed a notional percentage as a deemed perquisite. They struck it down. There were certain observations in the judgment of the Supreme Court that perhaps if this power of estimate of a deemed perquisite finds a place in the charging section, namely section 17(2), perhaps it may be legitimate. So as soon as this decision came, the government was very much upset. So they brought an explanation to section 17. Two explanations were brought, explanation 2 and explanation 4. Whatever was in the rule, they captured it and put it in section 17 to explanation 2 and explanation 4 from the day on which the Supreme Court gave the decision. It is no different from the rule. Whatever language is in the rule was completely copied and brought by way of an explanation. Now we have to now study whether this exercise of power of bringing the same language in a rule of computing deemed perquisite could be brought in by way of explanation to the main section. Now the defect, as far as I could see, in the present legislation, which is now in the statute book, which is with retrospective effect, what is the role of an explanation in a particular section? Does the explanation explain the section? Does an explanation go beyond the main part of the section, or tries to settle a doubt or a dispute with reference to the main part of the section? That is, main part of the section is perquisite which is in the matter of rent, and again concession in the matter of rent. Or three things are being explained in explanation 2 and 4. Is it possible that an explanation could remedy the observations of the Supreme Court? Is it possible? That is one question which we have to debate. Number 2, who is the authority to determine, assuming that the explanation is valid, that you have not deducted tax properly? Who is the authority? Now, as I told you earlier, the central government had constituted new circle called TDS circle at various places, and it is the TDS circle which goes and verifies these computation of deemed perquisite. Let us take a company which has got factories throughout India, and its base of assessment is, let us say, Tamil Nadu. The assessment is in Tamil Nadu, but its factories are located in Andhra Pradesh, Karnataka, West Bengal, Gujarat, etc., where each factory is as large as the factory in Tamil Nadu, where thousands of employees are employed. Now, let us take that this factory is somewhere near, not inside any town, because most of these factories have to be located at a far off place, for the reason that you require a large area, and secondly that residents should not be affected by any effluent coming out of that factory. So, there is a trend to locate it far away from townships. So, the TDS circle officials go and visit, give a show cause notice, get reply, and raise a demand notice on that factory manager to pay the difference. Now, the question for our debate is the TDS officer, who is not the officer assessing the company, the right first to inspect, second to give show cause notice, third to pass an order demanding the deficiency in computing perquisite value and therefore the tax deduction at source. And you will find that invariably in all such cases of survey, it is not only the current year of survey, but demands are raised for the current year as well as 6 prior assessment years. And you will note that because of the aggregate liability, the amount demanded is very huge. And if such an exercise is done in respect of many of its factories situated in every state, you will note the liability to be borne by the company. So, this is now taking place in the case of many corporates today. These are queries which I am posing. The next one is, all right, survey has taken place, act has been amended, rules are in force. Now, what should I do for protecting myself for the future? Is there any way out? Because the decision in courts of law is very uncertain. You may win at one stage and may lose at another stage, and even if you win ultimately, there is government to introduce a legislation retrospectively. So, it is very difficult to fight against the government. So you will have to arrange your affairs along with the government. There is no other way. Now how to get over this difficulty of deemed perquisite? It is very harsh, as I said, in cases where the factory is situated in a remote area. It is all right for an official drawing 5 lakhs per month and he is in Madras. Well, summed up there it is 15%. 15% of salary is deemed as a perquisite, which is again a fairly large amount, which will go into the reduction of his cash payout. You will find that the employee is affected. And if such a thing is imposed on every employee will like to have an increase in cash payout, because he is not bothered about Rule 3 or Rule 5 or Rule 6. My net inflow of cash should be so much. The result is that the employer has to shell out more to retain the employee, and which results in reduction of profit, which results in overall reduction in tax payment to the central government. It's a vicious circle. Is there any way out? How to satisfy the employee? Can we say, no, we will not give you any accommodation? You look out for yourself. Yes? Pardon? That is, you want arithmetically to increase his salary.
No, sir, nowadays cost to company is worked out now. This is my cost to the company.
No. See, the difficulty is this. What is cost to the company in the case of a rented accommodation? There is no difficulty. But as I gave the example, all these factories are situated at a place where private accommodation is not available. Accommodation has to be provided by the company at its own cost. There is no building available for it to take on lease. Most of the big factories are located far away from the township. No doubt there is an exclusion in the rule regarding companies carrying on mining activity, etc. But they have given a distance of about 10 kilometers. I think that will be too much of a difficulty, because as the progress takes place, townships are being formed even within 10 kilometers. So merely because a township is within 9 kilometers, you cannot deny the exclusion clause in Rule 3. There is but that is ineffective, because the distance that they have formulated might have been with reference to some database 10 or 15 years ago, but today we don't know the formation of townships. Very liberal townships are being formed, even though that area was never fit enough for a township. But that exemption is not very relevant, because majority of the people are not covered by the exemption. Now how to solve this problem? Now I will just stop here, and I would request your reaction, so that we will try to formulate something which is legally possible. Now this has happened in the last 1 or possibly 2 years. The demands made by the department are very large. Corporates are finding it difficult. Appellate proceedings are pending at various stages. Courts are reluctant to grant stay. They want 50% to pay. So these are all problems facing big companies. Now how to get at a solution? I have given you some 3 or 4 sets. What reaction I can get from all of you? Pardon? Form a separate company? No, no, please tell, because forming separate company everybody knows. But what happens next? What will you do? I form a separate company, okay. No, no. Is it a third party company or your own company? No, what is the company? According to you, the benefit should be provided by a third party. Am I correct? Yes. Unfortunately, the decisions are to the contrary, that if in the case of an employee, even if a benefit is provided by a third party, it is deemed to be a perquisite. People have already planned for your planning. That's the whole problem. I agree, sir, but the same rules will apply, because courts have said the benefit need not flow only from the employer. It can flow even from a third party. See, previously what they used to do, supposing there is a big company, they have got lot of distributors. Distributors were compelled to provide lot of benefits to officers of the company. So in order to get out of that, provisions are made that it can be even from a third party. So our planning to have a separate company or entering into a separate deal with a third party may not help us if there is really a deemed perquisite. Please remember, it is a deemed perquisite. It has nothing to do with the real benefit. The house may be leaking. You cannot live during winter. You cannot live during rainy season. There is no benefit at all, but you are compelled to stay there. Yes. Now, according to me, we'll go into the basics. First, we'll deal with jurisdiction. Because as I told you, the jurisdiction in all these cases is with the TDS circle having jurisdiction in the area in which the factory is situated, not the jurisdiction of the assessing officer. I went through the statute, but I have not found out any statutory provision authorizing any other officer other than the assessing officer to have jurisdiction over the assessee, because power to survey has been extended to many of the officials of the department. But the computation and the raising of the demand, according to me, should be made only by the assessing officer in Tamil Nadu and not by the TDS officer located at different places. I do not have any decision as to the jurisdiction of a TDS circle, but these are all coming up only recently. There is no case law available as to whether a TDS officer who is not the assessing officer can effectively compute the short deduction in TDS and also make an order demanding the differential. Are me? No, no. TDS returns are being filed, I agree. No, I agree. See, we are filing the TDS returns at the place where the TDS is being affected, because the TAN is located to that. It is only for the purpose of realizing the money and correlating with the PAN. So the PAN and TAN are going together. so that the officer assessing the assessee will have a picture as to the amount deducted and the amount paid. But is that officer who is receiving that return of TDS empowered to pass an order demanding the differential? That's the only doubt I am raising. He can survey, because all officers have been notified under 119 of the Act to carry out survey within their jurisdiction. The TDS officer Vijayawada cannot come to Chennai and do survey. No, he cannot do that. But he can effect survey in all places within his jurisdiction. But according to me, that power stops there. He can only report to the officer assessing the assessee that these are things I found out, please take necessary action. But they are not doing like that. The TDS officer himself is passing an order. Sometimes I have found a single order is passed for all 6 plus 1 year. No separate order, no separate demand. How to file appeal? How many appeals I should file? 1 appeal or 6 appeals or 7 appeals? And before whom? Should I file before my CIT appeal where I am assessed? Or should I file my appeal before the TDS circle having jurisdiction? Now when this issue came to me, I said file in both places, because it's very difficult. So if I file before CIT appeal, let us say Vijayawada, CIT appeal may say, no, I don't have jurisdiction. So supposing I file it in Madras, the CIT appeal in Madras will say, no, I don't have jurisdiction. So if you file at both places, 2 persons have to decide where it is. They can't just so make them difficult to decide. So in one case where this happened, the assessee is assessed in Tamil Nadu, but the TDS order, a very huge amount was made in Andhra Pradesh. So when I filed the appeal before the CIT appeal in Tamil Nadu, he raised the first question, how do I have jurisdiction? I told him that I am an assessee in your jurisdiction, so whatever demand is raised on me, you have to consider it. He said, okay, but I am not able to find out correct answer, so I will refer it to the higher authorities. So after some time I got a big packet from the CIT appeal returning all my papers saying I don't have jurisdiction. On basis of verification from higher authorities, I inform you that I have no jurisdiction, therefore I am returning back all the papers. Now what the other CIT appeal can do, supposing he says I have no jurisdiction, then I have to file this bunch again. That CIT appeal says he has no jurisdiction. Now if you say you have no jurisdiction, then who else has got jurisdiction? So this is a dilemma which we are having. Jurisdiction for TDS circle is not specified. So always better file at both the places. And the question is of filing fees. Now should we pay 2 1,000 rupees or only 1,000 rupees? Now my view on that was, I said it is a same appeal. For each appeal only 1,000 rupees. So wherever I file, the same 1,000 rupees will hold good, and file the same challan for both the appeals. Because the Act does not prescribe more than 1,000 rupees for an appeal against a particular order. This is only against a particular order I am filing. And again the question is, where there is a single order for 6 years, whether it is 1,000 rupees or 6,000 rupees. I only took the risk saying only 1,000 rupees. Let them demand 6,000 rupees. Why should I pay? It's a single order. So if he says defective, then I will pay. But no defect has been till today raised by the appellate authority. So possibly for a single order which is a combination of more than 1 year, possibly the filing fee is only 1000 rupees. Well, this matter is still at large. We do not know the jurisdiction, and possibly the taxpayer has the right to question the jurisdiction. Number 2 is the retrospective amendment to section 17(2) by way of explanation 2 and explanation 4. I have taken the view that by an explanation to a section, we cannot create a charge, because the courts of law have taken the view that a charge should be created by a specific section. The role of an explanation is to only explain or to clear a doubt, but by itself cannot create a charge. So that is one objection I am taking. The second one is somewhat more fundamental, namely a benefit or a concession, the two words used in section 17(2), should be real and should not be artificial. The rule-making authority or the statutory authority cannot deem something which is a factual position. If you see the Supreme Court decision in Arun Kumar, which I am going to give the citation, the Supreme Court has been very clear in saying that benefit, which is really perquisite, should be real. It should not be notional. It should be exact. Now the same house is occupied by two officers. One person is drawing 10 lakhs per month, another person is occupying 2 lakhs per month, but you will see the perquisite value is totally different for the same property. It is absolutely, you may say, unreal. Therefore, according to me, you cannot convert the requirement of a benefit which is a factual matrix. That is what the Supreme Court has said. It's a factual one. Benefit should be factual, should be felt, should be real. It cannot be converted into pure arithmetic just because you find litigation before the court. That is not the excuse. That is the excuse they have given. You cannot, just to reduce the litigation on the subject, bring a rule of thumb. So still we can question, notwithstanding the introduction of the explanation. Next topic. 3:30. Mr. Chairman has given me a query for our consideration with respect to the topic considered yesterday. Of course, it runs to more than one page, but I will read it because it is given to me only just now. In the month of September 2006, Mr. V gives a power of attorney to S, empowering him to sell his one ground house plot. As the house plot was near to a fishing kupam and within the coastal region zone of 300 meters, and the tsunami was still fresh in the memory of the public, no one is interested to buy the house plot. Yes waited for 2 years but could not find a suitable buyer. The month of October 2008, Mrs. S, that is his wife, came forward to buy the plot for 25 lakhs. As the guideline value was 60 lakhs, the sub-registrar refused to register the same unless stamp duty was paid on 60 lakhs. Mrs. S had to pay stamp duty on 60 lakhs to get the plot registered in her name. However, in the sale deed, the consideration was shown as 25 lakhs only, and this was acknowledged by the power agent on behalf of the principal. Now, Mr. S receives a notice from the AO in October 2011. The AO based his notice on the AIR sent by the sub-registrar. The AIR simply stated that Mr. S registered a sale deed for 60 lakhs. The issues are as follows. The principal owner, the power of attorney agent, and Mrs. S come under 3 different assessing officers. The assessing officer Y makes a demand on Mrs. S saying that in her tax return she has not shown the transaction, and so the AO is treating the entire amount of consideration of 60 lakhs as her undisclosed income. If the assessing officer passes an order against Mrs. S, she has to pay 50% of the demanded tax and go on appeal. The AO, another AO, X issues notice to S, the power agent, stating that S has registered the sale deed as seller and so he is liable to tax under 50C of the Income Tax Act, irrespective of the fact that S did so in his capacity of an agent to a principal, Mr. V. What kind of stand Mr. S can take in such a situation? If the assessing officer passes an order against S, he has to pay 50% of the demanded tax and go on appeal. What about the tax liability of the principal owner V? Well, this is, I think, very imaginary question. I don't think that such a thing takes place. Possibly such a situation may also be real. I am not ruling out, because each officer wants to make an order to protect himself, not so much as to whether it is correct or not. The principal reason for making an order is to protect himself, that is all. Now, gentlemen, the law relating to power of attorney is becoming more and more complex today. There are different types of power of attorney being suggested and executed. Because here this question does not say what type of power. I can describe a few of the power of attorney which is being given. Of course, there is a specific power and a general power. But so far as real estate transactions are concerned, whether it is a specific power or a general power, it makes no difference. One type of power of attorney where this owner gives power to another person to negotiate, arrange and sell his property, giving him full power to execute and register the document. Nothing else is mentioned. Sale consideration is not mentioned. The obligation to render account to the owner is not mentioned. This is one type of power of attorney that is now in vogue recently, few years. The second type of power of attorney is where the power agent is given power to negotiate, fix the sale price, take sale consideration, and not to sell below a particular rate, and whatever the price at which the property is sold, you must forward it back to the owner. This is a conventional power of attorney. The third one is a power of attorney, similarly worded, but without mentioning any sale value, but requiring the power agent render accounts. In view of lot of civil litigation, I don't know about other states, the Tamil Nadu government has brought a legislation that wherever a power is given to a power agent, whereby he is authorized to execute the sale and receive consideration, and where the power is to be registered with the sub-registrar, then stamp duty is payable on the guideline value of the property, as if this transfer is taking place under the power of attorney. Because government is losing revenue by keeping silent over such documents. So today, stamp duty is payable on the property at guideline value, even though there is no buyer, even though no real consideration has been received. This is to safeguard the interest of revenue, but not to transfer title in favor of the power agent. Title is not transferred in the name of the power agent. In actual practice, the owner of the property, when he executes the power, receives full consideration, normally. Otherwise, the owner will not sign the power, because it's a very extraordinary power he is giving. It is as good as sale. So in normal circumstances, the owner of the property receives the consideration at the price determined from the power agent, though nothing is mentioned in the power of attorney, with the result that the owner is not bothered about what happens to the power. He doesn't bother. Now the power agent, having secured possession of the land by paying the money, which please remember is not accounted money. Now, thereafter he negotiates sale of the property by virtue of the power of attorney. Now, for all practical purposes he is the owner, but in reality he is not the owner, legally he is not the owner. Now, he executes a transfer in favor of a third party and may get the same consideration he paid, or he may even get more than what he paid. But nobody knows what he paid to the real owner. Now in such circumstances, how you can determine liability on the gain arising? Is it on the original owner? Is it on the power agent, or an intermediary who purchases it from the power agent? Now these are all difficult questions which the income tax officer is not able to solve. See his difficulty. He is not a person knowing civil law, contract law, transfer of property law, stamp act. No, he doesn't know. And even if he has read it, he cannot arbitrate on that law, because he is to arbitrate only on the income tax law. Therefore, if he feels that all the three persons, according to me, are liable. Because according to me, there is a transaction, there is a property, because property doesn't disappear, it is there, property is there. There is a transfer of possession. There is an ultimate consideration, though intermediate consideration is not visible. But consideration as determined by the stamp authority is available. Under 50C, I can safely adopt 50C value. So I will adopt 50C value for all the persons involved in this transaction. So the fault is not with the ITO, but the fault is with the persons who do this type of business. unless the truth comes out, you cannot win the case. Department will not succumb by saying you have no jurisdiction to tax. It is happening in many cases. This type of entering into power, not registering it, and then after a long time registering with somebody else, all these are with a view to make the authorities find it difficult. So